Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
Complex, divisive and historic. Day one of the legal battle over Brexit Britain has seen the government make its case in the highest court in the land. The Supreme Court has been the setting. The question, can the government trigger Article 50 and begin the process of exiting the European Union without a vote in Parliament? And answering it, 11 Supreme Court justices sitting together to hear a case for the first time, which makes this a constitutional milestone. Watching it all has been our legal commentator Joshua Rosenberg, but let's begin with the Supreme Court President, Lord Neuberger, who opened proceedings.
I would like to take this opportunity to remind everyone who's taken an interest in these proceedings that the Supreme Court exists to decide points of law which fall within its jurisdiction. The justices of the court are of course aware of the public interest in this case, and we are aware of the strong feelings associated with the many other wider political questions surrounding the United Kingdom's departure from the European Union. However, as will be apparent from the arguments before us, those wider political questions are not the subject of this appeal. This appeal is concerned with legal issues, and as judges, our duty is to consider those issues impartially and to decide the case according to the law. That is what we will do.
So Joshua, Lord Neuberger there making it very clear that this case will be based on legal considerations, but he did acknowledge the strong feelings outside the court as well.
He did, and that's another first from Lord Neuberger, making a statement like this, well aware that the public is watching, well aware that the trial is being televised, and emphasising that it's purely being decided on legal principles, as indeed it was. There wasn't really any politics to speak of today at all.
So then, of course, it was over to the Attorney-General, Jeremy Wright, to set out the government's case. He summarised the three main arguments that would be made. Let's have a listen.
And my three submissions are these. First, that the foreign affairs prerogative is not an ancient relic, but a contemporary necessity. Including the powers to make and withdraw from treaties, it is a fundamental pillar of our constitution as a sovereign state, and it is essential to the effective conduct of public business. Second, that the prerogative operates as part of a dualist system, including in the EU context. And third, that the prerogative operates wholly in accordance with parliamentary sovereignty. Parliament has a clear understanding of the constitutional function and usefulness of these powers, and where it chooses to limit them, it does so carefully and specifically.
So Jeremy Wright there setting out the government's position. It's a big stage for him, isn't it?
It's a big stage for him. It's not something he's particularly used to. He was at the criminal bar before he became Attorney General and was made a QC, and he introduced the case and didn't really take it much further than an introduction, but he made this very important point. This case is about the prerogative. This case is about the government's inherent powers, powers that derive from centuries, powers, he said, however, that were totally modern and necessary and part of efficient government, powers that enabled ministers to sign treaties, to conduct foreign relations, without the need to go back and refer matters to Parliament at every opportunity.
It's worth focusing a bit more on this prerogative, isn't it? It was also something that was raised by James Eadie, who is representing the government, an important point that he was keen to make early on too.
The third submission in relation to the prerogative is this. Parliament is, of course, sovereign. It can choose to limit, it can choose to control the prerogative power in any way or ways that it sees fit. And of course, ultimately, it can choose to remove such power in any particular context altogether. So it is accurate, and more accurate certainly in the context of foreign affairs than using relic language, to describe the prerogative, again Lord Reid in Burma Oil, as, quote, part of sovereignty, which Parliament has chosen to leave in the government's hands.
So do you think that he made his point?
Well, he certainly explained his point, and his point is simply this, that ministers can do what they want to do, which is to trigger Brexit, using these prerogative powers, because Parliament has never taken those powers away from ministers. Now, the contra-argument is that Parliament never actually gave those powers, but what he's saying is Parliament is sovereign, Parliament could have taken away those powers from ministers, Parliament didn't, therefore ministers have those powers, therefore they can trigger Brexit, and they are not, as is alleged against them, undermining the will of Parliament when Parliament took us into the EU by legislation in 1972.
Now, he did have a few difficult moments over a very long day of sort of legal wranglings. One of the more challenging justices was Lord Carnworth, who was picked up on the issue of the Great Repeal Bill. This is what he had to say.
The thing that's puzzling me in relation to Lord Wilson's question is that you, in your case, make something of the fact that there will be parliamentary involvement once the Article 50 notice has been served, and indeed there's something called a Great Repeal Bill, which the Attorney General mentioned. Do we have any evidence about that?
About the Great Repeal Bill?
Well, yes, about what it is, what it's going to do. Because it seems to have some relevance to ask ourselves, well, what actually is Parliament's role going to be between now and the end of the 2-year period?
Yes, I mean, I'm sure we do, and we'll find. There's been, I think that currently there's simply been a statement by government about what it's intended to be covered.
I'm not even sure. I think there's been a statement of the Conservative Party conference. Has there been anything else?
Pass. We'll double check and get you whatever there has been on that. But I think there's no more than that at the moment. There isn't. Don't think a white paper or anything of that kind.
Slightly awkward moment there. The Great Repeal Bill is quite a big part of the government's Brexit plans, after all.
But it wasn't meant to be part of this case, and so James Eadie wasn't really prepared for it. In the High Court, there was absolutely no discussion of whether Parliament needed to pass a motion, pass a bill, what it needed to do. What the High Court said was simply that the government couldn't use its prerogative powers. Not only have we suddenly got onto the question of what the government will do, something raised by the Deputy President of the Court, Lady Hale, in a speech the other week, to some surprise, but we've got on to actually what it says. It's not really surprising, I think, that Mr. Eadie wasn't really prepared, although he did say that he would let the court know tomorrow.
It's worth looking actually just now at the reaction of Jeremy Wright, who of course is a member of the government. He doesn't look too impressed there by the fact that the facts aren't at James Eadie's fingertips there.
Well,
Closing
of course,
his eyes.
yes, he clearly could have answered this, and of course he could have got to his feet because, you know, he is the lead counsel for the government, and he could have provided this information. But he clearly thought discretion was a better part of valour. He didn't want to put James Eadie off his stride. He didn't even whisper anything to him. But I don't think he looked terribly comfortable, as you say.
Now, there were other challenging moments, some of them from one of the justices, Lord Mance, who appeared, shall we say, less than convinced at times. Let's have a look in.
Parliament is effectively prepared, isn't it, to do whatever the government decides without actually expressing a view itself. Is that realistic?
Well, the significance of those motions is, one, they're not primary legislation.
No, of course not.
They're not primary legislative authority. And you don't remove or abrogate the prerogative by passing a motion of that kind in Parliament anyway.
Does that involve the proposition that Article 50 is incorporated into domestic law?
It's become part of the listed treaties.
But is it incorporated into domestic law by this Act?
My Lord, it's not incorporated by this Act. It isn't. And I don't make that suggestion.
No, because it only operates.
It's not directly effective. It operates on the international plane, but it indicates that the rights and liabilities as they exist from time to time are subject on the international plane to that power of withdrawal.
Likelihood of the Council of Ministers and now the European Parliament agreeing to remove 99% of EU rights is rather remote, isn't it?
Well, my Lord, it may be rather remote in practice, but as a matter of law...
It certainly isn't done by unilateral exercise of the UK prerogative.
No, and I've made the point already that it isn't only our prerogative powers that are in play.
So off the back of that, it doesn't really seem like Eadie's had a great day, does it?
There was an awful lot of this close questioning. Lord Mance happens to know a great deal about European law. He's one of the judges who represents the judiciary to other European countries and so on. He travels to continental Europe quite a lot, and he was asking some questions. I think some of them James Eadie wasn't quite sure where he was going to. Others, they were quite difficult questions for Mr. Eadie. But that and the clip you played just before shows this very intimate relationship between counsel and the judges. You saw how close they are physically in this courtroom. It isn't as if the judges are sort of up on some great podium, but they are engaging, they are testing, they are challenging, they are testing the arguments to destruction, if you like, and that's the way the common law develops.
It does feel like a dialogue rather than a presentation.
Very much a dialogue. You have to be absolutely on your you have to know exactly what's going on, have to have all the information at the tip of your fingers, and if you don't know the answer, then you have to say, well, I'll come back tomorrow and let you know.
So lots of dense chat in court, but they did manage a few moments of levity, even a bit of humour over the complex nature of the case. Here's what we found.
Forgive me, Mr. Eadie, I'm back at references.
I'm so sorry. Was
is
that
it
too quick?
343 or is it 543?
It's core authorities 3. Do you have a set of files called CA?
On the electronic bundle.
On the electronic bundle, it's 1697.
It's 543.
I think you're saying it's bundle 3, tab 5. I think that's the...
No, it's volume 5.
It's volume 5.
Well, anyway, let's... Page,
I'm sorry, it's just confusing.
No, it is. It's in many places, I'm afraid.
I'm sure you're right.
Test the system to destruction by the end of this case, I suspect.
Yes,
You are right.
paragraph 43.
You are right, Mr. Eadie.
I am right. Good. At least that's something.
On this point.
66.
56.
56.
I think I gave you a wrong reference in relation to Lord
We did
Mance.
earlier on, but we
Was a
found it
mistake?
out.
11, 5.
Yes.
My lady found it first.
Well, that's why we need to know how to navigate, and then, because you can't get everything right all the time, Mr. Eadie.
A few moments of laughter there.
That was Lady Hale teasing James Eadie mercilessly. The point, of course, is that some of the documents, well, all the documents are available both electronically and in bundles of paper. Some of the judges use laptops, some prefer paper bundles, and therefore there needs to be 2 different page references every time James Eadie is calling on them to refer to a document, hence all the confusion about page numbers. But in fact, the judges are pretty sharp, and I think they were ahead of counsel.
And Joshua, what's your final thought at the end of day one?
I think that James Eadie had an uphill struggle. It can't have been easy facing 11 justices throwing questions at you from all directions. He was looking round to see who was going to ask him the next question. He has a challenge. He has to persuade the Supreme Court to overturn the decision of the High Court. He has the advantage of speaking first, but the disadvantage of trying to overturn an earlier decision from a respected court. Yes, they gave him a hard time, but I'm sure they will give a hard time to all the barristers who appear before them this week.
Joshua Rosenberg, thank you. Well, the government has had its say. It will continue again on Tuesday, and then we'll get the turn of lawyers for Gina Miller. You won't miss a beat on Sky News as we bring you live coverage, instant reaction and expert analysis on the Brexit challenge.